Convicted child serial killer Lucy Letby has had her appeal against her conviction rejected by the Court of Appeal. Letby received a whole life order, meaning she will never be released from prison for the murders of 7 newborn babies and the attempted murder of 6 more, making her the worst child serial killer in modern British history. Lucy Letby is currently serving her sentence at HMP Low Newton in County Durham and has protested her innocence consistently throughout the case. In this video, I'm going to explain how the appeals process works when someone appeals their conviction from the Crown Court to the Court of Appeal. I'm going to briefly cover why Lucy Letby's appeal was rejected, and then I'm going to talk about what are her options now she has had her appeal rejected. Welcome to my channel, Andy on Crime, where I talk about high-profile criminal cases and other aspects of criminal law in England and Wales. So the first thing to say is that there is only one reason or ground for appealing your conviction, and that is that your conviction was unsafe. Now this can mean a number of things, including errors during the course of your trial, the wrongful admission or exclusion of evidence in your trial, alleged jury irregularities, and errors by the judge in summing up. You cannot, however, argue that your conviction is unsafe purely because you disagree with the decision that the jury have come to. And before you can argue your case to appeal your conviction, you need to obtain permission to appeal, known as leave. This can be done in one of two ways. The first way is that the judge in the original trial can certify that the case is fit for appeal, in which case the Court of Appeal will automatically grant an appeal hearing, known as granting leave. In the vast majority of cases, however, the trial judge will not certify that the case is fit for appeal. It's generally only for very specific reasons, for example where a novel point of law has emerged during the trial, which the judge feels the Court of Appeal should review. For most standard appeals, this will not be the case. The second and most common way is to appeal to the Court of Appeal for permission, again leave, to appeal, and this must be done within 28 days of your conviction. When asking the Court of Appeal for permission to appeal, the defendant or appellant, as they are known in these proceedings, or their lawyers will draft something called grounds of appeal, setting out the reasons why permission to appeal should be granted. Now, permission to appeal is something that is considered by a single justice who can grant or refuse permission by considering all of the relevant documentation on the papers, i.e. they look at everything submitted in writing and make a decision without holding a hearing or considering any live evidence or submissions from counsel for the appellant. The single justice acts almost like a filter to weed out any appeals which are without merit from going before the full court. Now, if you are granted permission or leave to appeal, then your case will go before the full court, and I'll be more on that in a minute. If you are refused permission or leave, then you can appeal before the full court for permission to appeal again. You may be thinking, if you are refused by the single justice, should you just appeal to the full court anyway? Well, there is a sanction that can be awarded, which is put in place to discourage unmeritorious appeals. This is known as a loss of time direction. What this basically means is if you appeal against your conviction and your appeal is completely without merit, and your lawyers should be strongly advising you against appealing if this is likely to be the case, then the court can make an order that any time that you have currently spent imprisoned effectively resets. So if you've served a month of your sentence, that can be reset so that you serve a further month. Of course, for Lucy Letby, who is subject to a whole life order, a loss of time direction means nothing to her, so she will almost certainly appeal. So once the single justice has made their decision, the case will continue to what is known as the full court. This full court will usually consist of 3 Lord Justices of Appeal, although this can be increased to 5 or 7 if the appeal is especially important. The full court will conduct an oral hearing and hear submissions for counsel for the appellant and counsel for the respondent. Now, written submissions will have been made to the court already, and both counsels will usually submit what are known as skeleton arguments. These are, as the name suggests, where the lawyers set out in brief what arguments they will be making in court to expand upon in their oral submissions. Now, the hearing itself can be quite gruelling for the advocates, as the vastly experienced justices will ask a number of probing questions to the advocates, challenging their submissions in order for them to make a determination on the success of the appeal. And I know this from personal experience, having been lucky enough to appear once before the court and was asked a number of difficult questions. Now, one question you may be thinking is, can additional evidence that wasn't available at the original hearing be adduced during this appeal hearing? Now, the answer to that question is yes, if it is necessary or expedient in the interests of justice. And in considering whether or not to admit additional evidence, the court will ask itself a number of questions, including, is the evidence credible? Would hearing the additional evidence assist the court in making its decision? Would the additional evidence have been admissible at the original trial? And is there a reasonable explanation for the failure to adduce the evidence at the original trial? Now, the role of the Court of Appeal is not to fill evidential gaps left at the trial, and it is the responsibility of a jury and not the Court of Appeal to hear evidence and determine the facts of the case. When it comes to the decision of the Court of Appeal, there are three main outcomes that are likely to be announced. Firstly, the court can dismiss or reject the appeal and potentially award a loss of time direction at the same time. Secondly, they can allow the appeal and quash the conviction, and that's the end of the case, and the appellant is free and they will be released if they are in custody. And the third main outcome is to allow the appeal but to order a retrial, and the court will do so if it is in the interests of justice to do so. Now, there are some other outcomes, such as allowing part of an appeal or finding the appellant guilty of a lesser offence and adjusting the sentence accordingly, as happened in the case of Marine Sergeant Blackman, whose conviction for murder was downgraded to one of manslaughter by way of diminished responsibility. Turning back to the case of Lucy Letby, in really simple terms, her appeal failed because the grounds of appeal submitted by her legal team did not persuade the single justice that her conviction was unsafe, which is the test that I mentioned at the start of the video. As to what she will do now, well, with nothing to lose and no consequences for appealing to the full court, I am certain that that is what she will do. And the full court will consider whether to grant her permission to appeal or leave, and is likely to consider her appeal at the same time. They will then decide, when they come to make their decision, whether to grant permission and make a decision on the appeal. Given that the single justice has already rejected her appeal, there will likely need to be more substantial grounds in order to convince the court that she should be given permission to appeal and to convince the courts of the merits of her appeal. And separate to this, Lucy Letby will face a retrial at the same court in June on a single count that she attempted to murder a baby girl known as Child K in February of 2016. So to summarise, Lucy Letby appealed against her conviction on the basis that she believed her conviction was unsafe. Now, she sought permission to appeal from the Court of Appeal, and her case was considered by a single justice on the papers, who made a determination without holding a hearing, as is standard in all appeals that go to the Court of Appeal. The single justice refused permission to appeal. As to what will happen now, I'm almost certain that Lucy Letby will renew her appeal before the full court, given that she's got nothing to lose and there are no consequences from a loss of time direction because she is serving a whole life order. What I would say is it's likely that there will need to be substantially different or improved grounds of appeal from her legal team in order to convince the court to A, grant her permission to appeal, and B, to quash the conviction. That's all for this video. If you do have any comments, then please drop them down below. If you did enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.